I'm going to introduce you Ramón Hernández Peñasco. He's a lawyer. He was the secretary of the board of directors of Banesto, who nowadays has been merged with Santander Bank, but Banesto was one of the listed companies in the selective index of Madrid Stock Exchange, which is the IBEX 35. Then he is expert enough to speak about corporate governance, and the title of this research project is Corporate Governance Sustainability, with these three factors: ESG, environmental questions, social questions, and governance questions, and reputation. And then he is going to speak about reputation, and I think that all of us will discover some topics that will help us to go ahead with our research activity. Then you have the floor, Ramón. Thank you very much.
Good morning, everybody. Thank you very much for attending this meeting, and thank you very much to Alfonso for having invited me to join this interesting research project and to give this presentation about corporate reputation, in which I am sure I'm not going to discover anybody new for any of you, because this is an area where some authors have written a lot, but having said that, and from my practitioner's perspective, there is a lot of I wouldn't say smoke, but big words and general concepts, and it's a little bit abstract, in my opinion. Having said that, it's quite important, reputation, and it's increasingly important for corporate governance. Well, I've written in those first slides just some of the definitions of reputation I found. The first one is from the Spanish language dictionary, which says that reputation is the opinion or regard in which someone or something is held, or the prestige or esteem in which someone or something is held. No? Oxford Dictionary says that is the opinion that people have about what somebody or something is like, based on what has happened in the past. So the next slide, you can see some authors' definition. Those are authors who have worked on the corporate reputation field. For example, von Brunn said more than a definition, he decided to describe the main characteristics of corporate reputation, no? Which are, in his opinion, credibility, reliability, responsibility, and trustworthiness. Gotzi and Wilson, in a work written in 2001, said that is the stakeholders' overall evaluation of a company based in stakeholders' direct experience, communication, and symbolisms from the company, and inevitably, and I will speak about that some minutes later, the comparison with the actions of other leading rivals. I will come back to this important factor, as reputation is getting more and more important in terms of, or in the sense that it gives companies an important competitive advantage vis-a-vis the rest of its competitors. So after the definition, I think can be important to distinguish between corporate reputation and corporate image, because some authors, when in the past, when the research on corporate reputation began, mixed both concepts. So reputation was very linked to the concept of image, corporate image, but at the current moment, I would say that they are different concepts, and but there is a dynamic and bilateral relationship between them, in the sense that image influences corporate reputation, and the same in the other way around. I mean, corporate reputation, when a company has a good reputation, it influences obviously its image, no, in the market and with respect to clients and employees and the rest of stakeholders. Regarding the main characteristics of corporate reputation, and following Gotzi and Wilson opinions, I've put in this slide the main characteristics. No? It's a dynamic concept, as I said before. It takes time to build and manage, but it's very easy to ruin, to spoil the reputation in a very short period of time. So there is not a correlation between the time a company needs to build a good reputation and the time the company needs to spoil it or to ruin. No? Time passes by much quicker in terms of with respect to the ruin of reputation. No? Reputation crystallizes in the way or in a ranking perspective with respect to the company's rivals, and different stakeholders may have different reputations or different approaches about the company's reputation, depending on their different perspective, personal background, etc. Good. There are 4 key points to build a good corporate reputation: quality of products, services, employees, etc. Performance. It is the way the company works, both in terms of financially and in other factors such as innovation capacity, returns, etc. Responsibility, social, environmental, in terms of legality as well, and transparency, and attractiveness. No? The way the company is looked from the different stakeholders, no? In terms of differentiation from other companies, or authenticity, etc. What is clear is that a corporate reputation is getting more and more importance as time passes by. No? It involves a social evaluation of the company by the different stakeholders. It's obviously linked to trust, and a good corporate reputation generates some specific advantages I've written in this slide. No? The better economic result, loyalty, support on the part of its shareholders, increasing share prices, and a competitive advantage for the company. From an accounting perspective, reputation forms part of the concept of intangible asset, which is which are included in International Accounting Standard 38, which is the rule applicable to goodwill, intellectual capital, corporate culture, and some other important as well intangible assets. No? Of course, reputation needs to be managed by the company's directors as any other asset of the company, It can be measured, and in fact, there are different rankings of reputation. I've written there a couple of them, Merco and RepTrack, which are non-financial indicators that include reputation in their non-financial indicators, no, of a company. So the conclusion is clear. There is a growing interest in corporate reputation from both academic and company or practical perspectives. I would like to say something about the relationship between reputation and corporate governance, no? Because it's clear that reputation is increasingly or has an increasing importance, but now we have to deal with the relationship between this concept and corporate governance. No? I think the relationship is very clear, as corporate governance is one of the main or most important aspects of corporate reputation. I mean, the way the company acts in terms of transparency of the management, risks management and control, ethical principles and compliance culture, and power balance within the board of directors. All of those are important factors that contribute to build a good corporate reputation. No? The consequence, in my opinion, is that reputation must be defended not only from external attacks, which is clear, but also from threats coming from the company's governance system. I mean, if inside or within the company there are some inappropriate conduct in terms of ethics, obviously those conduct or this situation influences the corporate governance, the corporate reputation, and additionally the corporate governance of the company as well. No? So, in my opinion, corporate reputation has to be defended by the directors, and I think that it's clear that the defense of the defense of the corporate reputation is included in the duty of loyalty established in our Capital Companies Act in Article 227 and following. No? So directors have the duty or the obligation not to damage the corporate reputation as a result of an inappropriate behavior. Okay? And not only that, but the other main duty of directors, which is the duty of diligence, also has a close relationship with corporate reputation, as directors are obliged to defend the reputation of the company through the different means established in the legal norms or rules. I put there the 4 groups of laws which have a relationship with the defense of corporate reputation. Right to honor laws, which some years ago here in Spain was doubtful if legal entities were protected by right to honor laws, but nowadays this thing is clear, and they are entitled to use the right to honor laws to defend its reputation. No? Antitrust laws as well, labor and criminal laws. No? Any of those legal fields are are or provide different means to defend the corporate reputation. Apart of being defended by the law itself, corporate reputation has getting more and more important in good in corporate governance codes. As we know, corporate governance codes are not laws in the proper sense, but soft law. I mean, companies are not obliged to follow them, but in the event, according to the principle of complying or explain, they had to give, they had to state if they are following the corporate governance recommendations or not, and if they are not complying with the recommendations, they had to explain why they are acting in this way. No, so I have studied the different codes of corporate governance in Spain, and it's clear that the presence of corporate reputation in those codes has been strengthened increasingly. I mean, beginning with the Olivencia Code in 1998, the code just said that directors must have a good reputation, and that they have to be included in the causes of cessation or resignation of directors, those cases where the company's credit and reputation was in danger, no, because of their behavior. So the next code was the Lamar Code, 2003, and he recommended to include amongst the director's duties of loyalty the obligation to inform the company about any legal claim which could seriously affect the company's reputation. No? In 2006, the Unified Good Governance Code of listed company was enforced, and it recommended to establish some rules regarding directors. Some rules, to oblige directors to inform and, where appropriate, to resign in cases where the credit and reputation of the company was in danger. The Unified Code said as well that if a director was charged with any crimes related to company law, this is an important nuance to take into account. I will refer to it later on. Then the board should study the case as soon as possible and to decide whether it's appropriate for the director to continue in the company or not. And this situation and the board's decision should be reported and explained in the annual corporate governance report. In 2015, a new corporate governance code was enforced, and it stated that the causes of removal and resignation of directors shall not affect the freedom of judgment, and that they protect the company's credit and reputation. And it maintained the need to identify reputational risk in similar terms to the code, the Unified Code 2006. Furthermore, the 2015 code included the need of evaluate non-financial risks of the company and included those reputational risks between amongst those non-financial risks. No? And it also established the obligation that the company set up a special commission or committee within the board of directors to supervise the compliance with corporate governance rules, internal codes of conduct, and corporate social responsibility policy. In this new code, 2015, the previous concept of crime related to company law, I mentioned before, was changed, was enlarged. So from 2015, directors must notify to the board any offense they are involved in. So the board may act and may decide what to do with respect to this director, no? And it also put in force the necessary report by the Nomination and Remuneration Committee before the board takes the relevant decision about the directors, no? This decision by the board may have, according to the code, different content. An internal investigation may be open if this is the decision by the board, or the board may request the resignation or even propose the dismissal of the director. In any case, the decision must be disclosed in the annual corporate governance report, and information to the market must be disclosed, must be issued at the time the decision is taken by the board. On the other hand, the functions of the audit committee or commission regarding non-financial risk were reinforced. So amongst those functions were included those related to non-financial risk, including reputational and corruption related risks. And those reputational risks were also included in the internal audit function of the company. Additionally, the corruption risk were also included in the scope of the risk control and management policy, and different mechanisms for monitoring non-financial risk were also put in place. The 2015 code was revised, reviewed or revisited in 2020, very recently, and the main conclusion of this revision were those you can see here in this slide. Early warning regarding situations that may affect corporate reputation. It established a higher proactivity by the board. The Nomination and Remuneration Committee had to be involved in the decision to be taken by the board, and it was established an increased control of the reputational risk by different mechanisms such as the audit commission, internal audit, and the control and risk management and sustainability policies of the company. So those are, this is the content of my humble work on this matter, and I hope it can be very useful for all of you.
Yes. Can we share afterwards the PowerPoint presentation?
Yeah, sure.
Thank you very much, because humble or not, and I think that it is not that humble, I think that it is very useful, because you have put in clear that reputation is an abstract concept, but related, for instance, with the
But more and more important
international accountability standards. If the accountancy of the company, which sometimes is one of the bigger preoccupations of the members of the board of directors, refers to reputation as something measurable in terms of money. I think that
the risk.
Yes, the
topic
is important enough. No, then here.
Of course, you have here my email address if you need to.
Yes, but
contact me at any moment.
But we will send the PowerPoint presentation to the
attendance,
to the members of the research project. Then following, hi Teresa.
Hi.
Then following the order of business, the different points for this session. If you like, we can for some short minutes interchange our opinions with Ramón about the lecture. Which, as I said at the beginning, I think that reputation can be connected with we will see, or maybe you have seen in the document that I have sent with the description of the project, that one of the specific goals is to speak about remuneration of the members of the board of directors. You have explicitly connected this topic, for instance, with reputation. Then you would like to make any questions to Ramón, please. Avelina, Alonso Escamilla, you have the list of all of us. I made groups related with our subjects or expertise. Avelina, Alonso Escamilla, for many of us, is well known, but for those of you who she attended to the international conference that we organized last November, a year ago. She's a professor of criminal law. Interdisciplinarity is one of the ways to be successful, as we, thank God, have been attending to a call for research projects. Then criminal law is one of the subjects which are connected. Avelina and Ángela Casals. Ángela and Maria Jesus and Geraldine will be the three people who will help me to send you emails. And so Ángela is also a doctor in criminal law. Then please, Avelina.
Good morning to everybody, and thanks. Alfonso, you are our inspiration in this project. And thank you very much, Ramón, for a very interesting lecture. And I was kind of lost in translation when first Alfonso asked me to join this project. But as you have said during your lecture, I have taken some, I think, good ideas just to think about. It's very interesting what you have told us about reputation and linked with behavior and criminal law.
Yeah.
Because I think that reputation, is held on behavior, but if we talk about ethical behavior, we are not talking about criminal behavior. As ethical behavior may belong to deontological codes, I may say, while criminal behavior are those behaviors without contents on criminal codes. So when you talked about cessation or resignation of directors, I think we have to separate those ethical behaviors from criminal behaviors. And as different professions, as lawyers, doctors, have their own ethical codes or deontological codes, I mean, director is not a profession. So I'm not very sure if directors have kind of deontological codes or only are adjust to ethical behaviors. And I think this is a good point, just to think about it. Or I think I could begin to think about it and, link those ethical behaviors with those criminal behaviors, because it's a very different question. Criminal behaviors belong, as you all will know, to a public law, while those deontological codes are, included.
Ethical.
Yeah.
No?
So I think these ideas are very interesting just to think about.
Yeah, well, in commercial law, which is my discipline, we have the law, the Companies Act, mostly, and apart from that, we have some codes which are voluntary for companies, for listed companies, even though now there are some non-listed companies codes as well, which are getting more and more importance as time passes by. And those codes are full of, or reflect of many ethical rules, let's say, and not too different in some cases from those ethical principles included in lawyers, doctors, or I don't know, architects, sorry?
Engineers.
Codes, no? So it's clear that this is something outside the field of criminal law. Criminal law, as all of us know, is the most protective field of the law. I mean, crimes have to be clearly typified in the code, and just in those cases where the infraction of the criminal law is very clear, this person may be sentenced. No, so but in the criminal code, the Spanish criminal law, there are two crimes related to reputation, which are the crimes. I don't know how to translate it into English. I'm sorry. Injuria y calumnia. I mean, when someone attacks the good reputation or the credit of anybody else, no, in a grave way. I mean, no? In those cases, those or the criminal law allows the state, the judges, to sentence this infraction. No? So, but it's different. I mean, voluntary codes and criminal law are moving in totally different.
In parallel words, I would say. Yeah.
Yeah.
Because can you really oblige to resignate a director for an unethical behavior? Compulsory, I mean. Because if that director says, well, I am unethical, but I'm not going to resign, what can you do?
Well, the general meeting, the shareholders' general meeting is entitled at any moment to dismiss a director. So if he or she doesn't want to resign, the shareholders may force his or her dismissal. Yeah.
Ian McNeil, many of you may remember Ian took part in the international conference that we had last November, and he was also my host at when he was a dean of the law school, which is a kind of torture that now I am suffering as a dean of this law school. He was my host when I was at Glasgow University, and he wrote about comply or explain, and Ramón has been also a victim of this kind of torture, if it is, because he was the one who had to send the information about compliance plan to the Spanish supervisor of the stock exchange. Then, Ian, please.
Thank you very much, Alfonso, and thank you, Ramon, for a very interesting presentation. I picked up on the point you made about the International Accounting Standard number 38, and I find that a very interesting point that is not very well developed in the literature so far. And the reason I think is interesting is that, you know, if it's the case that companies would begin to create an asset based on reputation, this potentially provides a counterbalance to the cost of sustainability, because we often talk about sustainability as the internalization of externalities. And of course, this is costly for companies, and it's one of the challenges to achieving sustainability. But of course, if some of those costs could be represented as an asset in the balance sheet, then the problem of what we might call financial sustainability could begin to be resolved. Now, my question is, you know, so far my understanding is that I don't think many companies have begun to move in this direction, but perhaps you have some indications that actually this is beginning to be beginning to be something that companies are doing. And so, you know, perhaps if you can speak a little bit about that, do you see this as something that is likely to happen in the near future?
Yeah, thank you very much, Ian. Well, International Standard Accountability 38 set out the different intangible assets and the way they have to be recognized in the balance sheet of the company. Okay, but let's say that those assets are seen by the accounting regulators with a lot of caution. I mean, they not provide the right to the company to include in the balance sheet any asset they can, let's say, invent or something like that. Okay, so in very limited cases, the company is allowed to include amongst their assets the reputation, the goodwill, and the rest of intangible assets. No, so I don't think a company at the present moment can include in his balance sheet the value of its own reputation. A different case is if this company is sold to a third party, and the price this third party is paying is higher than the real value of the assets of the company. In this case, the purchaser, the buyer, is paying a higher amount that can be recognized as goodwill or as an intangible assets. So only in very limited cases, the value of intangible assets may be included in the balance sheet. But no, it's not the same case as when we are talking about tangible assets. No, imagine you buy a piece of land and you begin to build a house or a factory on it. So in this case, you may include in your balance sheet the investment you are doing in the construction of the factory. But this is not the same. It doesn't happen with the value of reputation. You're in mute.
Yeah, sorry, but of course I see that we could probably expect that the value of reputation will be captured in the share price, even if not in the balance sheet, because, you know, that will, you know, we would expect that, given that it could be achieved on sale, we would expect the share price now to reflect that value, I think.
Yeah, sure.
Yeah.
Yes, the share value is obviously influenced by the value of the reputation of the company. This is something very, very clear.
It's a more subjective value, more subjective than the value in the balance sheet.
Of course, but it's something that we can think about a lot of examples in the practice of our life. No, we prefer to buy in a specific shop and not in other, and in some cases it's because we have heard of cases of where the shop or the shop employees, for example, have behaved badly with clients and this kind of things, or you are not allowed to change the article you've bought because their policy is very restricted, very limited. So you prefer to buy in a different company, or in a different shop. I think this is something we know about.
Thank you very much.
You're welcome.
Thank you. Then Teresa Serrano Sordo, as well. I am introducing shortly some of us who are well-known people. Teresa was the compliance officer of Citibank Spain when Citibank Spain was here in this country. Now they have an office, but she has been also working in other companies of the financial sector. She is a doctor in commercial law and now works in an institution, Patrivalor, who is an institutional investor manager, and she is professor of this university as well. Thank you, Teresa.
Thank you very much, Alfonso. Thank you so much. I'm delighted to be here today. I'm sorry for the inconvenience of the parking related topics. Now, I wanted just to raise one point connected with what Ramón was saying, and it's that, I'm also of the opinion that it could be, a reputation could be created as an asset. But the point of view from my compliance experience as well is because one of the compliance risks for companies now is precisely the damage of the reputation of the company is one of the core compliance risks. So compliance is all about that. It's about reputation plus the risk in which the company incurs where there is a breach of the regulatory framework. So from that perspective, I think that I could even say that perhaps that could be within the non-financial risk structure, because at the end of the day, the reputational risk is part of the compliance risk, and therefore is one of the non-financial risks that, by the way, our Spanish law and the Ley de Sociedades de Capital, and the company's law, says that it would be one of the facultades indelegables de consejo. It's one of the board of director faculty that cannot be delegated. So from that perspective, I think it's becoming more and more important. And it's a matter of how that concept is developed in such a way that the reputational risk perhaps acquires more importance than any other compliance or non-financial risk. But, and as you said, Ramón, I fully agree with what you said with the sale of the company, but even more, the zero ISOs topic is becoming, for example, in a due diligence, in the sale of a company, more and more important. Because you have a look at the risks in here, and you have zero issues, reputational plus compliance. That adds value, and there's no no doubt about that.
Yeah, and reputation indicators or metrics of reputation are increasingly getting more and more important. So Merco and some others are getting more and more important in practice. And well, at the end of the day, as you said, or implicitly, it's an intangible asset which is floating around the company, And obviously, all the stakeholders around the company know when the company has a good or a bad reputation, no? And they act accordingly with this approach, no? With this. So I fully agree with you.
Mm-hmm. I don't know if Ian has another question or if the icon with the hand still remains from the previous question. Yes. And yes, okay. And nevertheless, I think that to follow the timetable that we established, we should first thank again Ramón for his brilliant, humble maybe, but brilliant lecture. Thank you very much.
My pleasure.